Good morning, everybody. I am Diann Cohen, and I'm joined by James Rossi, and we are here today to provide to you a special program just for you at Gallagher Bassett. We're really excited to be with you today. So before we get started, I do want to let everybody know that we will be providing 1 CEU credit for this. And so you should be receiving that within 1 hour of the program. Some of you might have some pretty strong firewalls, so you might get it a few hours later. But if you don't get it for some reason, please let me know. I can help you within the first 30 days, but after that, I can't help you if you didn't receive it. So please make sure to reach out to me. So MacroPro is a proud partner with Gallagher Bassett. We've been working with Gallagher Bassett for many, many years. And James Rossi also does a lot of work with Gallagher Bassett. James, how are you this morning?
I'm doing well. I'm hanging tough. How are you?
Good, thank you. I'm excited to be doing this program. I think it's really great what we're going to be able to provide on apportionment and what is happening. So I'm going to turn it over to you right now, James. But I will say this to our audience. If you have any questions, there is a question box that you can put in. And at the very end, if James and I get a chance to answer them, we will. If not, we will try to email you back with a reply on your question. And so feel free to do that. And maybe while we're waiting and James is getting started, could you just type in there what city you are actually located in? It would be very interesting for us to see where you guys are at. All right, James, let's get started.
All right, let's do it. Thanks, Diann. First of all, I want to say thank you very much, Gallagher Bassett, for having us. It's definitely an honor to be here with you today, and I think we're going to have an interesting session. We're going to talk about permanent disability, apportionment, getting records, ratings, things like that. We're going to start it off with actual ratings per permanent disability, and we're going to talk about that because you don't get to apportionment if you don't have permanent disability. So basically what happens in a nutshell is you got an injured worker, and I'm not necessarily going to follow all these slides, just so you know, you don't have to read everything in here. But we are going to make these slides available for you so that you have this information to look at some point in the future. In fact, it may already have been provided to you. So what happens is you get an employee, he gets injured and he ends up having to go to the doctor, he gets treatment, he gets taken off of work, put on temporary disability. And then at some point, the treatment is done, the applicant can't get any better. The treatment is done improving, and so they will say this applicant has reached maximum medical improvement, and that's the magic word to say it's time to rate the injury. At that point, the doctor will have to assign a whole person impairment for whatever the disability, the body parts are, and they will then have to, if there's multiple PD ratings, they'll have to combine them together, and there's this chart, combined values chart, that when you combine them, it allows you to have one PD rating for multiple body parts. So for example, this chart will have, if I had two 10 whole person impairments that I needed to join under this chart, it would turn into 19%. So it wouldn't actually be 20%, even though it seems like it would. It doesn't work that way. And that's what this combined value chart is. And then obviously, once you've got that final rating, that's when you figure out what it's worth, and there's a table for that. And I'm sure not all of you already know all of this, but it's just a setup. So that's the book, the 5th edition of the guides. This is where we get all of our ratings in workers' comp for the most part. And it's got chapters on every body part, every body system. The ones that we use the most would be chapter 15, which is the spine, which includes the cervical, thoracic, lumbar spine. The chapters that we also use almost as much as the back would be the upper extremities, which is chapter 16, and then chapter 17, which is the lower extremities. Those are the most common, but there's everything, and there's the respiratory system. I mean, you name it, it's in these guides. A lot of the chapters we use very infrequently, but when you get like a high exposure case that has numerous specialties, that's when you start looking into all these other chapters as well. So this is an example of a rating so that you can see it. We used a 46-year-old male shipwright, that's a shipbuilder, and he injured his neck building a wooden boat, and the QME assigned 15% whole person impairment using DRE3, and he apportioned 100% of the disability to the industrial injury. So in other words, none of it was non-industrial. The calculation was done, and actually, Diann, why don't you tell us about your calculators, because that's where this was done.
Yeah, so this particular tool is available to all of you. So as long as you have a username and password, you can utilize this. And this calculator is really simple to use. You can see here, you're going to put in the date, the age of the person, when they had their injury, their date of birth, and the date of the injury. And you're just going to basically fill in all the blanks. But you'll notice here on occupation, so what's really cool about ours is when you do an occupation, you get the grip code, and then it gives you a description of what that is. And that way you know for sure that you are rating on the proper job. Because sometimes it's like secretarial 1, 2, 3, or mechanic 1, 2, 3, or whatever the case is. They have different levels, and you want to make sure you're rating on the correct one. Then you got the body part. You see there, then this one, it's a spine. And what is really cool is once you hit spine, you're gonna have like this real quick 3-second blip, and then only the things that relate to the spine are going to be pickable when you go through for impairment. So it's awesome. You're not looking through and weeding through everything. You're just getting what is pertinent to what you need. And then you're going to take the doctor's whole person, slip it in there, what the apportionment is, put it in there, and then you're going to hit that you're going to compute the formula, and it'll be there. And what's really cool about this is during the period when there was plus and minus 15%, it's smart enough to know, and it will automatically give you the plus and minus 15%. It's an outstanding tool. Plus you can cut and paste the string and put it into your file notes. And now, James, why don't you tell her what's going on? Why don't you tell everybody what's going on and how you use this tool?
Well, I think these tools are amazing, because what we used to have to do was go through and each individual part of the rating we would have to do ourselves, and we had a book, a rating schedule, and we would go through the book, and it was all done by basically with a lot of it was similar to math. Some of it was math, which attorneys are not very big fans of. So these calculators are wonderful, because it just spits out all the information so easily to where I can run a calculation as long as I have the amount of apportionment, the amount of whole person impairment, the age and the occupation, date of injury, and date of birth, and I'm set. So it can make very, very complicated calculations simple as can be. Even when you get life pensions, it can be very simple because of this. So it's a wonderful tool.
Well, let me just ask a quick question real quick.
Sure.
So while
of course.
people are listening to you, if you still do it the old-fashioned way by hand, could you put that inside of the chat so we can see how many of you guys are doing that? Because maybe we need to get.
I hope.
I hope not too, but some people like.
I am curious to see if anybody is. It's not necessary anymore by any means.
Right.
These calculators are amazing. But all right, so let's talk about a string rating. This, as you can see, that's a string rating up at the top there. And that first number is really, really important, because that tells us how much of it is industrial. So we always want that number to be as low as possible, because if it's low, then that means we get to cut the amount owed. So for example, in this particular case, you'll see at the end result was a 28%. Well, if that 100% was a 50%, meaning 50% work related, 50% non-industrial, we would only have liability for 14%. And 14% is much less money than a 28, obviously, and it's actually less than half of a 28. 28 starts, the higher you go, the bigger each percentage, the more money each percentage is worth. So getting that apportionment is just so important. So the 15 is the chapter, and I was telling you there's all these chapters. So if this was a upper extremity injury, it would be 16. Then you've got the 010100, that is the body part, the method, and the variant. So for example, here we used a DRE3, and I'm not going to go too much detail because you really don't need this. You just need to know, am I doing a DRE3? You plug it into the calculator, it'll be there. If it's If it's not a DRE3 and it's range of motion, well, maybe it's based on a fracture, and that's where that 0-0 would change. So moving on to the next number is the very critical number. That's the whole person impairment assigned by the doctor. So in this instance, it was a DRE3 15%, and so that's what we use in running the calculation. And then you'll see the next number, that's the diminished or the future earning capacity modifier, and it's basically for diminished earning capacity. They made it a standard 1.4, which prior to this, there were only a couple body parts that got a 1.4 multiplier. For example, psych was one of them. Everything else was on a scale lower. And so when they changed it to 1.4 across the board, they actually increased the PD on a lot of body parts. It was a good thing for the AAs, a win for them. Because as you can see, that 15 automatically changes to a 21. And so it's definitely something that's increased the exposure for us, which, the applicants do need to have an increase in exposure at times as well. So it's not really unfair in my opinion. The next one is the job 380H. That is the occupational group number. So we have a shipwright, which builds ships. So as you can see in the Macro Pro calculator, it says shipwright there, and 380, that's the number that it gives. And so it adjusts. And so that occupation adjusting, it turned to 21 into a 26. Then the last variation goes from 26 to 28, and that's when you do an age adjustment. And so what happens in this particular instance, since he was 46, it went up 2%, and we got a final rating of 28%. But let's assume he was 40 years old instead. That 26% would have stayed the same. If he was 60 years old, that 2% would have been more like 5% or 6%. And if it's like a 22-year-old, it actually goes down. So that 26 could go down to like a 21 or 22. So age is really important, and the younger they are, the lower the disability. The older they are, the higher. And then if they're right between 37 and 41 years old, there's just no adjustment at all. So that's the anatomy of a string rating. The combined values chart, this is where what I was saying earlier, this is not a full chart, just so you know. It would actually keep going down to 50. This page would go down to 50, and then it would be through 50 on the bottom, and then you line them up and you see what it is. So for example, this here, 1, 2, 3, this would be a 5 and a 5 right here, because down here at the bottom it would be 5, it would be a 10. So that's how we do it, the combined value. But there's calculators again that can do your combined values, because what you do is it's pretty easy to do on the chart, this particular task. But what you do is you just put them all in, and it'll combine them all and give you the final number very easily. But if you were using the book with the actual combined values chart, then at that point you would want to make sure that you were combining the largest with the second. So you take the largest, you take the second largest, and you add it. Then you take the next one and the next one, but you always start with the two biggest. And this I'm gonna show you a few slides that I think is gonna surprise people. I know when I first noticed this, I was surprised, and I've told a number of people over the years, and they're repeatedly surprised. But this particular slide just shows you an example as to the difference between a 99 and 100%. Once you get to 100% PTD, this was a max earner, 40 years old, didn't adjust for life expectancy, which you'll always want to do. You want to adjust for life expectancy, because people will have comorbidities, they will have various issues going on in their life that you want to get a rated age, because they may be 40, but with all their medical conditions, they're really like a 47-year-old, which then limits a life pension, because they're not going to live as long to collect it. So when you want to adjust for that. But we didn't do any of that here. We just made it simple. In this instance, 99% is $637,000. But if an applicant attorney could turn that into 100%, it's 2.797 million. That's a gigantic difference, over $2 million difference. So that 1% is why we fight so often. We're always thinking, how can I get it for 99% and avoid that 100? And that's the reason why. That's more of a dramatic one in a sense that it is a max earner, and if the lower the earnings, it can be less dramatic, but it's there. It's always very, very dramatic, just maybe not quite this dramatic. And this is the part I was going to tell you that's so surprising. So I got a case here, central and peripheral nervous system, that 71%, and it rated out to a 99. And you'll see the 1.4 modifier, it got it up to a 99 just by itself, and then the age and occupation didn't even change it. So based on that, you can see if you, and actually the math is this, if you get one body part of 72%, it's automatically going to be a 100% case once you do the 1.4 modifier. So that's a magic number. But if we took this 99% and we want to get it to 100, and we're an AA, and the AA's doing everything they can to get to 100, and they say, okay, well, there's a cervical spine injury of 28% that I get to add to this 99%. That's going to put me at 100, right? The answer is no. Okay, well, what if we add a 36% for the lumbar spine as well as the 28% to the 99? Does that do it? No. What about if we add a 49% on top of all of that already for the left lower extremity? Still no. Okay, well, the right lower extremity, 49%. So now we got a 99 combined with a 28 combined with a 36, a 49, and a 49. And are we finally at 100? No, it's still 99%. Getting from a 99 to 100 is so hard, and it takes one body part of 50% or more, one body part, not multiple body parts combining for 50, one body part has to be 50% by itself to combine with a 99 to get 100%. So I'm going to show you this. Here's basically what we did is we cut and pasted just this relevant part, which is 99 combined with a 1 is a 99, combined with a 6 is a 99, combined with 11 is a 99. And then if we go all the way over, now we've got, at the end, if we add a 50, we finally get to 100. So check that out, 49%. You can add unlimited 49s and you're never going to get to that 100. You're going to still be at that 99 because every time you add one in, it's just going to stay the same. So I personally was very, very surprised when I saw this. It really puts into perspective why it's such a price difference between a 99 and 100 in terms of the value of the disability. All right, so next we're going to talk about, we are going to get into apportionment. As I said, we're going to talk permanent disability, because you really got to understand that. And I'm going to touch some of the ways that these applicant attorneys try and get cases to 100%. And I'm not going to go into detail because these analyses are very, very fact specific. They're complex. There's a lot to them, but it's just important for you to know the types of things that are available to the applicant attorneys that you'll see. All right, so first is Almaraz-Guzman. I'm sure you guys have seen this come up a number of times. This was at first this was crazy. Basically, doctors would say, well, under Almaraz-Guzman, I believe the guide's rating is insufficient, and the most accurate impairment rating would be A, B, C, and they would come up with these just crazy ratings and out of nowhere, and they would leave the guides, the AMA guides, the green book that I showed you earlier, and so it was creating a big mess. And fortunately, the court came in and they cleaned it up. And they said, you have to stick to the four corners of the guides. You can't be leaving the guides and making all of these, using other tables, using other issues to change the disability. It has to be something in the four corners of the guides. And then on top of that, the doctor has to explain very well why they need to use Almaraz-Guzman and change the rating. So for example, example that I've seen a number of times is upper extremities worth 60%. If you lost your whole arm, it's 60%. And so maybe the applicant had some sort of a surgery and is having issues, but it only rates out to like 10%. Well, the doctor can say his issues are much greater. His activities of daily living are impacted much more than a 10% rating. And so therefore, I'm going to apply Almaraz-Guzman, and I believe he only has 50% of the use of the arm. And so since 60% is the whole person for an arm, I'm going to assign 30% whole person impairment instead of the strict rating of 10%. So that way it's a fair and accurate rating. And that's the kind of stuff. And so as the defense, we need to be able to show that it's not justified, that the strict rating is proper, that there's nothing unusual here, and that's where a lot of litigation is created. So that's Almaraz-Guzman. We see it a lot. I'm sure you all have seen it, maybe not know exactly what it means, but that's what it is. The next one is that they'll use a case called Kite. And this is where, as I was showing you with the CVC, when you add, added a 10 and a 10 and it's a 19, well, you lost 1%. And so, and the higher you go into all this, you're going to lose even more. When you add them up in the CVC, you're going to lose even more percentage points. And so what Kite did is they came and they said, well, we don't think all cases should use the combined values chart. We think some cases should just be added. And so if it's a 10, you just add the 10. You don't, say you got two 10s, you just add them and you get a 20 instead of using the combined values chart, which turns it into a 19. And as I said earlier, the higher you go in permanent disabilities, the harder it is to get an increase. And so actually adding changes everything. It makes it much easier to get to a life pension or more. And so what they do is they'll say, well, these body parts have a synergistic effect on each other. In Kite, for example, you had a bilateral hip injury. And so the doctor said, if you do a strict rating of each hip and then you don't combine it, it wouldn't be fair for the applicant, because when one hip is injured, it's impacting the other hip and they have this synergistic effect. And so therefore, I would combine by adding rather than using the value chart. And it changes it because you don't get that discount. I mean, technically, when I showed you the 99 added to a 36, you're at 100% already. So it's a way for them to really increase the permanent disability. And I've seen so many ridiculous arguments on this. They're trying to get Kite. You got an upper extremity injury and a lower extremity injury, and they're trying to say, oh, well, there's a synergistic effect and it shouldn't be added instead of combined, and so on and so forth. And we see all kinds of arguments. Some of them are just so ridiculous, and others are actually legit and pretty good. But I would say more likely than not, it's an argument that should not have merit. Then there's Ogilvy. This one used to be a huge mess. It was just absurd, but it's gotten a lot. It's cleaned up a lot. The main one that you're going to see, in fact, it's almost the only one I ever see, is that they're not amenable to vocational rehabilitation. In other words, they can't get back into the workforce. They don't have a future earning capacity. And so what they'll do is they'll get an expert, and the expert will say, okay, I'm looking at all the work restrictions, and based on all these work restrictions, I can't find work for this applicant. It's just not available. And so they have to do a thorough analysis of it all and look at what jobs are available and various other things, and their report spits out the results, and then they have to put reasoning into why they're doing what they're doing. And so essentially, if someone is unemployable and say they had a 50% case, but then there's an opinion that they're unemployable, they could become a 100% case that way. And so it's something that has created a lot of litigation over the years. It's definitely very complex. And what we do is we go and get our own experts and refute it and show that they didn't consider proper things, or they included things. The biggest one I see is that they'll include non-industrial factors that are not allowed to be. The case law is clear that they're not allowed to be included, such as the general economic conditions, illiteracy, proficiency in English, or lack of education. And those ones come up a lot. So it's definitely something that is a pain in the you-know-what, and it's not. It creates a lot of arguments and a lot of litigation, and it honestly it increases settlement values when they go get these experts. Unless our expert is really, really good and refutes it all, then we're good. But then we had Nunez 2 that recently came out, and this is a good case for us, because what was happening is these experts were just giving their own apportionment, and they were saying ultimately this person is unemployable and not applying apportionment based on the doctor. So the doctors say, okay, 50% of this is non-industrial, 50% of it is industrial, and they would say, well, he's unemployable, and they would assign their own apportionment of 100% work-related because of the unemployability. He was working before the injury, now he's unemployable. So any condition he had beforehand, he was able to do, obviously, because he was doing it until he was injured. And so they would eliminate the medical apportionment. Well, this case came in and said vocational apportionment is not proper. It's the doctors who decide apportionment. So what that means is you're still going to see vocational expert reports, but at the same time, you're going to have the doctor review them, and the doctor is going to be the one that decides. It's not going to be this vocational expert. And there's vocational experts out there that literally will find, in my opinion, from my experience, and this is just my experience, 100% every time they're referred a case. It's just what they do, and then we've got to refute them. And we'll use things like surveillance. We'll do all kinds of things to refute their reports. But this was a good case for us. All right, so now we're going to get into apportionment. And apportionment is just dividing and allocating. That's what it is. In California workers' compensation, we've got Labor Code sections 4663 and 4664. That is what controls apportionment now. 4663 is what we always use. That's where we're determining the causes percentage-wise. So if you've got an injury, a disability, a back injury that has two causes, one is some non-industrial accident, one is the work-related accident, then they can split it up and have a percentage that was directly caused by each. And then we're only liable for the portion that is actually industrially related. That's 4663. So we look at all kinds of things, and I'm going to show you a slide of some examples. 4664 is one that you use when you've got a prior award. So let's say, for example, someone had a prior back injury that had 10% permanent disability, and it settled, and that was the rating, or it stipped, and that was the rating. Then a subsequent injury happens, and it's now 20%. Well, the first 10% is presumed to still exist. They can't get paid twice for that. And that's what 4664 is. And just so you know, it's our burden to prove apportionment. When I was talking about those other methods to increase, almirez, et cetera, that's the applicant's burden, not ours. This is a bummer. No apportioning other benefits. So even though there's, some other accident is largely at fault for any disability, something non-industrial is largely at fault, we can't apportion any of the TD, medical treatment, or death benefits. So, and the basis for that is they didn't want to undermine expeditious delivery of the benefits, creating a hardship to the injured workers. All right, 4662. This is an interesting one. This is a case or a code section that has 4 designated conditions that are conclusively presumed, meaning not rebuttable, conclusively presumed to be 100%. And those are the eyes, which makes sense. If you can't see, I mean, you're 100%. Both hands, same thing. Practical total paralysis, yes. Mental incapacity, yes. These are all quite obvious. Of course, they have to be shown. You know, they just because they say they don't have use of both hands doesn't mean that they really don't. So, for example, I had a case where the guy had his hand taken off, just chopped it off. I don't know if it was the first, but it's definitely one of the first cases or injuries where they reattached a hand, and they successfully reattached it. And so in that case, they were saying he had zero use of the hand, and he's got which is a 60% whole person. And ultimately, we were able to show just a little bit of use of the hand. He was holding a piece of paper, he was holding some car keys, he pushed a door shut, and then in deposition, he said he can't do anything at all. He couldn't do any of those types of tasks, so on and so forth. So that would show that hand was not, that arm was not, had some use. And so just imagine if it was both hands and you show some use, and that's how you would get around that. But it's definitely problematic. I had another case many years ago where the applicant she was blind, total blindness, and it was, in my opinion, was clearly non-industrial. She had diabetes that was just terrible. She worked in the field. She tried to claim it was chemical exposure that caused it, but it wasn't chemical exposure. It was the diabetes, and there was no question. So we went to a QME, and this QME gave this opinion of 5% of it's work-related. And I was going, are you kidding me? 5% is work-related, 95% is related to her diabetes. The liability that would put on us is huge, because you got this presumed total disability under 4662 since it was blindness. And then there's an argument that you may not get entitlement to apportionment. The case law is split. I would argue you can, because under 4663, which is where you're dividing apportionment based on percentages of the cause, that would mean you would have to go, okay, that 95 should count, even though there's a conclusive total disability. So you'd say, okay, it's conclusively 100%, but I still get my apportionment. That's in litigation. That's unsettled law. And in this particular case that I had, the attorney says, well, obviously the PD is not the issue, where the exposure is, since it's only 5%. And so he made a settlement demand based on the other stuff. And what he should have been doing, and clearly didn't know about 4662, is he should have been arguing, especially back then, when the law was even more favorable, he should have been arguing 4662 is 100% and there's no apportionment. It's conclusive. And there's some case law that would have supported him, but he didn't even make that argument. All right, so now we're going to talk about some things to look for when it comes to apportionment. Prior industrial injuries. It includes any awards. So you want to make sure that you have all prior awards when it comes to, and prior injuries that have any permanent disability listed so that you can get that apportionment. And so that's one of the, some of our clients will like us to put in an accepted case, they'll like us to put the disability that we're agreeing to and put it specifically in the CNR and say this settlement is based on the rating of such and such doctor, which rates out as follows. The parties stipulate that the applicant has 18% whole person impairment, because then if there's an injury later on, we know we got it 18% right away, boom, we're gonna get it, no problem. Another one is prior non-industrial injuries. This includes motor vehicle accidents, slip and fall, sporting accidents, any kind of accident. It can be anything. If it was an injury outside of work, it can be apportioned to, and you need to gather whatever you can to show it. Subsequent injuries. This is one I feel like is not looked at as often as it should. Maybe, if you got a case that's been going 3 or 4 years, it's a good idea to run another EAMS and to run an ISO. Every now and then, we find out that we wouldn't have known if we didn't run it. We find out the applicant had another injury. Most commonly, I see they'll have a motor vehicle accident, and they have a civil case and it comes up in the ISO, and if we didn't run that ISO, we would have never even had any idea. And so it's important to think about subsequent injuries, and we can ask about them in depositions and things like that. Prior symptoms or complaints, even if it's a deposition, and I'm in the deposition with the applicant, and I get him to say, yeah, before the injury, I had trouble moving my arm. I was having a lot of issues moving my arm, and now it's worse. Well, if that kind of testimony is presented to a doctor, you're probably going to get some apportionment. It's hard to show apportionment though, because the doctor would say, well, I need the records. But I've seen it where even without the records, the doctor will say, I attribute 10%, or something along those lines. I'm being very conservative, giving 10% because I don't want to overstate it since I don't have the records, but clearly it would be at least 10%. So prior symptoms or complaints are important, even if you don't have records. Risk factors, even if not symptomatic, and genetic factors, those are kind of tied together. So for example, there's a BRCA gene for women that will pretty much guarantees if you've got this gene, and unfortunately the women in my family largely have it, they're going to get ovarian and or breast cancer at some point in their life. And unfortunately in my family, it runs rampant. And so let's say someone who has a genetic disposition of a gene that suggests that they'll get cancer of some sort, and they then make a cancer claim, you're going to be able to get apportionment for that genetic, the fact that they have the gene that makes it more likely, you're going to get apportionment for that. So you want to know what the genetic factors are. Obesity is a big one. When I see obesity, it causes a lot of problems, not just on the joints and degeneration and respiratory system because they can't move, diabetes, you name it. It's obesity is a killer. Age, although not insufficient in itself, age is a big one because typically if I see a 65 or 70-year-old applicant, they're going to have a lot of findings. They're going to have degeneration in the knees. They may already be candidates for knee replacement, things of that nature. I know if I go to a QME, there's going to be permanent disability almost every time with these QMEs on a 65-year-old who's been doing any kind of arduous or even remotely arduous labor. You're going to get hit with it because age is just, we get findings as we get older, simple as that. So you can't say I get apportionment of X percentage just because this applicant's 65 years old. You don't. There has to be actual findings in diagnostics or whatever that shows that they actually had, that they had some kind of findings there. Smoking, drinking, drug use, these can all lead to apportionment. You got a respiratory injury, for example. I've seen apportionment to smoking be very, very high percentages, non-industrial. In fact, I've even seen it where the doctors have said the smoking was the cause and it's non-industrial because of the smoking. Drugs, drinking, same type of issues. They cause a lot of medical issues that can impact a claim, especially if you're talking about a more serious claim where they have lots of specialties. Comorbidities such as diabetes, heart disease. Heart disease is a big one because we have a lot of, and I know Diann's got some things that she's going to talk about, so I'm going to speed through a little bit faster here. But comorbidities such as diabetes and heart disease are important because when someone has, for example, a heart attack at work, it's almost certainly going to have a pre-existing component to it. You don't have a healthy heart and then all of a sudden have a heart attack because something stressful at work happened. It doesn't work that way. It's usually going to be over time. It's going to you may have a genetic predisposition to it, and so you'll ultimately get a lot of apportionment typically on heart attack cases. The findings in the diagnostics, I'm always looking for degenerative findings. A lot of times you get an older person and their MRI is going to show and X-rays are going to show lots of degenerative findings, arthritis, and maybe a surgical candidate such that they need a knee replacement, which is not unusual in people's 60s. So it's there's going to be disability there, and you're going to want to make sure you get the apportionment for it. The date of injury is another one. If you can show that there's 2 dates of injury, you can actually reduce your exposure. So to give you an idea, if I had a 100% case and I reduced it into 2 50% awards, my goodness, I just eliminated so much of the permanent disability exposure. It's crazy. And that's obviously an extreme, but if you got, you know, a 50 versus 225s, you're going to pay a lot less too. It just, if you can break it up, and it also is a way you can avoid 100% case, because you can say, well, I need apportionment for this other date of injury. Hobby sports and other ADLs. I want to know everything about this applicant. What have they done their whole life? What are their hobbies? What sports do they play? You know, do they shoot guns? Whatever it is. You know, I had a case where the guy shoots guns all the time. He's claiming a CT to the shoulder, and you know, shotguns are not easy on the shoulder, and this is what he did. And so clearly, that was going to entitle us to some apportionment, and it did. Non-industrial psych issues. Psych issues can really cause a lot of problems, whether it be a feeling that their injuries are worse than they are, that they can't control, things like that. But if the psych injury is non-industrial, then get your apportionment. Now, apportionment requires discovery. We do things, medical canvases to identify subpoena targets. We do depositions of the applicant. That's a biggie. Witnesses, you know, employer witnesses may know where this applicant treats, complaints, you know, any medical problems. We do an AOE COE investigation, surveillance, social media, and background check. All of these are great tools to get apportionment. And then the key is apportionment is our burden. So we need to make sure that we have substantial medical evidence to support a finding of non-industrial apportionment. This is a tool that it's under 4663D, which is the apportionment. 4663 is the apportionment statute that I was talking about, or the code. And that is, you can send an interrogatory to the applicant where they have to, upon request, disclose all previous permanent disabilities or physical impairments. It's been tried to be used to go further, you know, but it asks for medical treaters and things of that nature. But the code specifically says this, so this is enforceable. All right, and Diann, why don't you jump in and talk about some discovery tools? I think you're off.
Got it. Thank you.
There you go. All right.
So this is always exciting for me because I love it when we can help with apportionment and really help get money back so the employer isn't paying for something they shouldn't. So some of the tools we have available to you that are really great are OCR. So OCR records come to you automatically when you use MacroPro. You pull up your records, and if you wanted to find like a certain body part, you would type in that body part. So left elbow, for example, and then every page that refers to left elbow would pop up so that you could see that. So that's a big time saver for you. In addition to that, we will provide to you one free EDEX during the life of your claim. And what an EDEX does is it provides history of any other workers' compensation case that they would have. Also, a lot of times you don't have time to go through the records, but we just know that there should be more records and the injured worker isn't telling us about. So you can have our MP discovery, where one of our employees will put their eyes on your files and look for any other locations, and then let you know where those locations are so that you can either subpoena or use an authorization form to get those. And there's a small charge for that. We have nurses that are that do medical summaries, but they also now do something called the injury focus. And what that does is for QMEs, because James, right, there's all these records that you're going through and you have to present. You want to make sure that the records that you send are really relevant to the claim. So you give us a body part, and we'll go through and give you just the records for that, any comorbidities or anything else that might be helping your case and you should be aware of. So it's a nice way to cut down your page count, and that is called the injury focus summary. We also do a breakdown on your x-rays. So why is that important? James, do you have any ideas why that would be important?
The x-ray breakdowns?
Yeah.
Well, I'm always looking for x-rays and I'm always looking for MRIs, and I want to know exactly what they say because they're pretty much what tells the story in most cases.
Exactly. And so what's really great about this is we give you an breakdown. So let's say we're talking about a knee injury, but if we give you a breakdown and we find out that they had a hip issue or a back issue, you might be able to say, look, I don't own this claim 100%. Here are these others. So by having the breakdown, you're going to be able to get this discovery, this free research, and figure out what it is that is actually going on. And you can address that in your claim. We also will do Social Security and disability and Medicare verification. So you don't have to go to your MSA company for that. We can do that for you. Sometimes we do it faster because this is what we do day in and day out. Other tools that you have available to you are the rating calendar that we looked at early on. It'll do combining, so it could be more than one body part, as we mentioned earlier. Future date calendars, which is great. Nice to be able to not to look at a wheel and try to figure out the dates. Earning calculators, interest awards. Here's another one that's really kind of good. It is a doctor hospital listing, and this is really fascinating. 10 years ago, I was in a client's office and we're showing them how to use this tool. She says, well, I'm going to put in the doctor that a lot of the claimants utilize in Modesto. She put it in and he didn't pop up. It's like, why didn't he pop up? So then we went down to the license, the state board licensing, and we see that his license was actually suspended, and yet he was still practicing. So these tools are really great because they help you with so many things. Next slide. And I think, James, this is for you. Maybe you can tell him a little bit about why you guys subpoena and what you're looking for with certain subpoenas.
Yeah, sure. So whenever we get the ISO, we get the EDEX, we EAMS searches, we look and see what providers were part of a case. We're looking for any clue that we can tap into to get some apportionment of prior injury and show that the injury is not ours. And definitely prior claims is a very, very big one. And so what we'll do is we'll take a deposition, we'll get the EDEX, the ISO, we get the information we have on the prior claim, take a deposition, ask them about the issues in that case. We'll start by getting just get the WCAB file, because we don't have to give notice to the other side when we get the WCAB file. But if we start subpoenaing records right away before a deposition, then what happens is a copy goes to the AA reviews it, prepares the applicant, and then they can, basically I want the deposition to be a lie detector test. And if they already know what I know, it's not going to be effective. So once I've taken the deposition, I get denials quite often. It's surprisingly often. Then I subpoena all the records. And so now I don't care if they know about it, because I already locked you under penalty of perjury, and you're in some trouble. So we use those, that's how we use the EDEX, the ISO, et cetera. And then we're also looking at for any treating physicians, such as in the medical canvas, we'll find prior treaters, and we'll go after all of that. Sometimes the treaters in our case will reference prior conditions, prior treaters, things like that we'll go and get records for. Sometimes there's other employers. Maybe you want to subpoena another employer. Maybe you find another employer on their social media account. So you want to go subpoena them because sometimes they have evidence of insurance, medical insurance, or evidence of a prior condition, or out of work slips due to injury or illness, whatever it is. There's stuff in employer records that are quite good. And then criminal records also can have, depending on when we do the background check, those can have some nice nuggets in there as well. So we try and do subpoena everything that there is to subpoena that could potentially help the case without going overboard. We don't want to waste money either. But if it looks like it's a good use of money, then we go and get it.
Excellent. All right, so let's talk about getting records from one state to the next. A lot of times we are trying to get records from other states, and I just did a webinar seminar the other day, and an examiner said, I didn't know I could actually subpoena records from another state. You can. You can do it using the Uniform Interstate Deposition and Discovery Act, the UIDDA. Basically, back in 2007, a group called the Uniform Law Commission decided, you know what, this is crazy. We're trying to get records from one state and the other state, and there's no way for us to do this fluidly, seamlessly, and it takes a big job. When I started in this industry 27 years ago, we would send a California subpoena to New York or Wisconsin or wherever and hope that they realized that they didn't realize that our subpoena had no teeth. But as the places got more and more sophisticated, that just didn't work. And this commission came in at just the right time.
Hmm.
So what it does is basically it takes a California subpoena and then it makes it legal in the other states. It harmonizes it. It has a process and it works great. We have 47 states that have adopted this, as well as the District of Columbia and the Virgin Islands. However, we do have 3 states that do not, and that was Missouri, New Hampshire, and Texas. So does this mean we can't get records out of them? No, that doesn't mean we can't get records out of the state. It just means we have to do something different. Now, Connecticut and Massachusetts are also part of the UIDDA, but they have a special requirement all of their own. We basically have to hire a local attorney to do the paperwork for us. But you know, we monitor it, we make sure the paperwork is done right, etc. So this is a really outstanding way to get records from other states. Most places will not do this because it is a lot of work, but don't worry about it. You need records from out of state. We will be happy to help you with that.
Yeah,
Next slide.
the thing is, sticking with this for a second, is over the years, when we've had to get cases from out of state, we've had to go and hire attorneys in that state, and it's just so hard. So this, people, you should know about this. This is a really nice service, and there's times where you will need out-of-state records for another injury, etc. And you're going to want those records really bad. So having this option is so much easier than what it used to be.
Absolutely. You know, people living in different states now, people traveling, it's
Oh
crazy.
yeah,
Speaking
absolutely.
Speaking of traveling, a lot of people would like to get records internationally, but how do they do that? It's very difficult. We actually have a whole department that does this. We will get records internationally. In fact, we've been on 6 continents and gotten records from more than 33 countries. We've learned a lot. A couple real quick stories. We had records that someone wanted to get out of Mexico. And in Mexico, basically it's they don't want to release these records. But we're calling this facility and they said, no, we're not going to release records. And then we're a virtual United Nations, so we have lots of people who speak Spanish. Well, it took about 7 attempts, but we found somebody with the right dialect, and that was the whole difference. And they said, no problem, fax this over your authorization form, we will release these records to you, and we got them. And we found out in Israel, for example, there are 12 rabbis that do a tribunal and decide whether or not records are going to leave the country. So there is a lot of work to do it, but it can be done, obviously, because we've gotten them from so many different places. James, next. All right, emergency services. So a lot of people are saying, I can't get emergency service records. Well, you can. It's not done by the injured worker's name and the date of their injury. The way that it works is, where did the emergency service vehicle roll up to? So we need a date and an address, okay? Date, time, and address, and that's the way that they're filed. And I'll tell you an interesting story about that in a second. Next slide. All right, ISO. James talked a little bit about ISO. ISO Search is the world's largest database, and this is important to you for a lot of reasons. First of all, it is a database for property and casualty. You're like, but excuse me, Diann, we're workers' comp. Why does that matter? Well, because it is a really robust, intelligent platform. It can actually detect like fraud issues. And so if they're going to commit fraud, for property casualty issues, why wouldn't they do it for workers' comp? They would, right? Because that's just who they are. And so what they will do is they could detect certain things. For example, if they have multiple policies, the only reason they have multiple policies is because they're going to commit a fraud, right? They want to collect on both ends 2 different policies.
Seen it multiple times.
Yeah, and then also too, if they've had any prior SIU claims. Well, if they're doing that in property liability, that should really make you think, my goodness, there's probably something that's going to be going on here. And what was it? Because now you can use that evidence against them, obviously, right? If they use multiple social security numbers, why? Everybody has one. Why do you need more than one? In addition to that, it will also give you other fraud indicators from the from other insurance companies. So it's a great tool. If you have it, please make sure you include it with your order for records. Next slide.
Yeah, and one other thing is always make sure your defense counsel has this. This is my #1 tool because we get so much out of these ISOs. They're just amazing, and we don't have access to them. You have access to it. We don't. So you got to provide it to us.
So Uncle Sam, he's an interesting guy. So he wants his authorization forms. His authorization forms. He doesn't want yours. He doesn't want mine. He wants his own. So if you're not looking at the screen, please look at the screen right now. Look at the first three, the military records. So the thing is a lot of people want to get military records, but they've been unsuccessful. And my guess is because they've always provided one authorization form, you know, to get the records. What you need is the second one. The second form says that it's a request for information needed to locate records. Now, this is really important. The United States has closed down so many bases around the world. Where are those records? They're nowhere in particular. So we have to search for them before we could copy them. Okay, so we can get Navy, we can get our Social Security information, earning and benefits. You also have to have a consent release for Social Security. And then veterans, we can get the VA records for you too. Now on the VA records, if you have somebody that has been disconnected with the military, retired, or didn't opt to serve more, you can ask them for their DD-214, and a DD-214 is all of their military records. Ask your document retrieval company to meet them somewhere, wherever the injured worker wants to be, and then they can copy that record. It'll save you about a year. And you should know almost all military records take about a year. So if you can get a shortcut with the DD-214, please do that. And remember, you can get your Social Security verifications and medical verifications with MacroPro. Next slide. Trying to get this done so we can get it done in an hour. We're really close. We are. We're going to do it. So James was talking about background check and how important it is. Well, we have this amazing, great tool. We have a social media and background check that you can get from us. So it's going to give you, you know, criminal histories. It's going to give you any aliases, any prior addresses, and that's really important because, especially if you're going to do a medical canvassing, because you want to know where they live because they're probably getting their treatment and their medicine around them. So you want to know where they would live. And then any traffic violations. This is kind of important to know. If they were in a car accident, they may have a prior injury, right? So that is a really great tool to have. And then our social media, of course, is going to give you all the typical things that you will get with social media, but bundled together, these are an amazing tool. So we did one for a client. It was for an employee that came in with a busted finger, and it was unwitnessed broken finger start of the day. So what we did was the social media came up and said that this person was an MMA fighter. And we found out that he actually had a fight the night before. Well, we still couldn't prove that he broke his finger there, right? But what we did do was we went to the organizer of that fight because they have to have police and ambulance there. And so police records show, no, he didn't have any altercations, but the ambulance says, yes, we treated him. Guess what we treated him for? A broken finger. So now the examiner can say, hey, you know, injured worker, what would you like to do with this? We know that you lied to us. You're trying to commit fraud. Would you like us to close this down, or would you like us to pursue a fraud claim against you? Right. So
well, just so you know, though, we don't ever mention the word fraud.
Okay, very good.
But we say it, we couch it in ways where the point is made.
Yeah, well, that's why you do what you do and I do what I do. We're great at getting the records, and you're really good at making
Yeah.
sure you get this thing
Using
set
them. Yeah.
right. Exactly. But this is an amazing tool. So please don't forget about it because this is really, really excellent. Next slide. Medical canvassing, so we all know what that is. We kind of spoke about it, but I'm going to say that the first thing you want to do when you do a medical canvassing is go to the pharmacy. The pharmacies are the ones that usually work and help us the best, and you get so much information. You know who the treating doctor is and what they're prescribing for, right? You can see what type of medications that they have. So this is a really great tool to utilize. And you can use it for many things, but I always say start with that. If you have a medical release form, it'll be much easier to get information out of any medical facilities, because then we can say, look, we have the release forms and they're more willing to work with us. Next slide.
All right, so this is basically we're at the end. And this is just kind of some highlights for the discovery plan. You want to make sure that you get your discovery professionals like MacroPro, and then you want to make sure you get the applicant's deposition or statement if he's not represented, so that you can get all the prior injuries, conditions, treatments, complaints, you name it. This is your opportunity to get a lot of information, or to get information that shows the person's a liar. And that obviously will help a case as well. When you're assessing credibility. You're going to want to subpoena all the relevant medical facilities. You're going to want to get your reports from your PTPs. If you need supplementals, get them. If you need to depose them, get them. Just make it so that they provide a report that's substantial medical evidence. Until they do that, their report is worth nothing. And sometimes it's a QME that you like the opinion, but you want to make sure that it's going to be admissible. So you're going and trying to fix it and make it substantial so that there's actual reasoning supporting the opinion rather than just a conclusion. And then if you get vocational rehab experts, challenge them. Get your own expert if you need to. But most importantly, vocational apportionment's done. So they're going to have to review the apportionment given by the doctor, and the doctor is the one that decides. And then they're not going to be able to just give their own opinions that go against the doctor if the doctor has substantial medical evidence because of Nunez. And so you can have the doctor address the voc rehab report, but it's much, much cleaner in light of Nunez than it used to be. So, but that's it in a nutshell. And if you have any questions on any of this, you can reach out to me at any time. I'll give you an email address of jr@ca-sil.com, jr@ca-sil.com. And if you have any questions, feel free to reach out to me. I also have my defense reference sheets, the laminated reference sheets. If any of you, I know some of you have them. If any of you that don't have those, please let me know, and I will send me your address, and I will make sure you get a copy of it in the mail.
Okay, and you can put that in the question box. Just say, you know, I want one. That's all you need to say is I want one. We'll go ahead and get that to James, and he'll get the email with that and get your address. Couple things. You will get your certificate in approximately 1 hour. There are handouts to today's program. You can download them so that you have it, and James and my information is on the last page. So maybe you can get to the next page and they can see that, James. And then in addition to that, we have about 9 webinars. It's a summer school series. In July, you have to give your hours for continuing education to the state. So we are trying in June to make sure we shore you up and you get all of those hours. And if you want to see this again, you can go to the MacroPro YouTube channel, and you can see this very program as well as other programs as well. So I see that people are putting in there that they would like to have it. So we're going to leave this open for just a moment longer. So please put that in there. And we thank you all for attending. We hope to see you at one of the summer school series. James, are you going to end up doing a summer school series top?
Yeah, we'll do one. We'll do one.
You'll do one? Sure. Excellent. Yeah, well, I know people are asking for you specifically. So that would be great after the MacroPro and Friends that we did in Orange County. All right, well, we're going to go ahead and close down the webinar at this time. And again, if you didn't get a chance to put down, I would like a copy. Don't worry about it. You can email me or James and let us know. And I'm just Diann, D-I-A-N-N @macropro.com. Thank you, everybody. Bye-bye now.
Bye, everyone. Bye.